The domain name dispute I'm talking about today reminded me of the critical nature of deadlines in UDRP proceedings. This case involved an unusual situation in which a domain name registrant tried to abuse the system by seeking an extension of a deadline, but ultimately the UDRP panelist rejected the request. Although these requests might not arise frequently, this case is a good reminder about how timelines apply in cases under the Uniform Domain Name Dispute Resolution Policy. Hi, it's Doug Eisenberg, and as I explained in episode 3 of my masterclass on domain name disputes, the UDRP was designed to be a relatively fast legal process for trademark owners to deal with cyber squatters, and a typical UDRP proceeding takes only about 2 months. But despite the rigid timelines set forth in a UDRP case, there are some opportunities in which deadlines can be extended. So trademark owners and domain name registrants should be aware of these nuances. Because a UDRP complaint can be filed by a trademark owner at any time, the most important deadline in any proceeding is the time in which a domain name registrant or accused cyber squatter has to file a response. Here's what the UDRP rules say on this issue. First, Rule 5A says that a response must be submitted within 20 days of the date of commencement of the administrative proceeding, which typically means the date on which the UDRP service provider, such as WIPO or the forum or one of the other providers, submits the complaint to the domain name registrant. The rules don't specify whether this is calendar days or business days, so it's important to consult the provider's supplemental rules, which handle this differently. For example, the forum, which is based in Minneapolis in the United States, makes exceptions for certain deadlines that fall on U.S. holidays. But WIPO, which is based in Geneva, Switzerland, makes no such exception. In any event, Rule 5B of the UDRP gives a respondent or domain name registrant the right to request an extension of 4 calendar days to submit its response. And the rule makes clear that the provider shall automatically grant the extension and notify the parties thereof. In other words, this slight extension must be granted upon request. This is a relatively new addition to the rules that did not appear until 2015. Next, Rule 5E allows for additional extensions, although they are within the discretion of the UDRP provider and are not automatically granted. Specifically, this rule says that a respondent may request an extension to file a response in exceptional cases or by written stipulation between the parties. The rules don't specify how long the extension may be, but given that the original deadline for a response is only 20 days, it would seem that anything longer than that might be unreasonable. And in fact, that appears to be the case in a recent UDRP proceeding, filed by a prominent lawyer who was representing himself. According to the WIPO decision from January 2021, the domain name markrandazza.legal contained the attorney's name and was being used for a website that contained false and misleading information about the attorney as part of an effort to pressure him to stop representing his clients. But the reason I'm talking about the case now is because of an issue that arose during the UDRP proceeding about deadline extensions. According to the decision, the domain name registrant was granted the automatic 4-day extension, but the registrant also requested a 30-day extension, to which the complainant objected. It appears from the decision that WIPO appointed the panelist without granting this 30-day extension, and here's how the panelist dealt with the issue in the decision itself. The panel first notes that at various times, the respondent wrote to the center asking for more time, but no response was ever filed. Nor was counsel for the respondent ever named. One communication said, "Our expert is not available now," or copied. The panel notes in particular in that regard that the parties have encountered each other before in legal disputes. The panel considers, therefore, that the requests for an extension were likely motivated by an attempt to delay, and that the respondent has had a fair opportunity to advance any facts and arguments he may have in the instant proceeding, but has not availed himself of this. In other words, the 30-day extension was never granted. And by the way, the lawyer who filed the UDRP complaint won a transfer of the disputed domain name. Now, here's one more item I want to mention about deadlines before wrapping up. As I'm recording this video in February 2021, it's a timely issue that might not apply in the future, but it relates to the ongoing COVID-19 pandemic that is disrupting lives and businesses everywhere around the world. On May 20th, 2020, as part of an update on its domain name dispute operations during the pandemic, WIPO published a notice saying, as the situation continues to evolve and impact individuals and businesses worldwide, parties are kindly requested to understand that a degree of flexibility and discretion may be appropriate or necessary in individual case scenarios. And in its commencement notices, WIPO is currently informing domain name registrants that the due date for responses may be extended on request. As far as I know, this policy has not been abused. So, the bottom line is this. A response to a UDRP complaint is due within 20 days, although a 4-day extension may be granted upon request. And further extensions are possible, especially right now because of the COVID-19 pandemic, but unexplained requests for lengthy delays are usually not granted, which means that even with these slight delays, the UDRP remains an incredibly efficient domain name dispute policy for trademark owners. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.